the question is not agreed by a majority of each of the, respectively, of each of the two groups of members, I declare the motion negative.
請各位肅靜。
Please keep quiet.
力嘅議案辯論打擊。
Debate on motion with no legislative effect. The motion debate on combating bid rigging to defend the rights and interests of property owners. Silence, please, members. I have yet to call you. When members who intend to speak on the motion, please press the request to speak button. I call upon the Honorable LAM Cheuk-ting to speak and move the motion. Chairman, President, I move that the motion as printed on the agenda be passed. Recently, the pro-establishment members frequently queried my service with the ICAC. I'd like to take this opportunity to tell you about my work with the ICAC. The last 2 years of service in ICAC was mainly involved in anti-bid rigging activities. My superior asked me to be the team leader of a major enforcement team. Team 1, we had to arrest the head of a bid rigging syndicate with tribe background. I went to his luxury flat, 3,000 square feet, enjoying a full sea view. I took him to ICAC's vehicle. He said he wanted to go home. I said, why? He said, I had to change my shoes. I've been arrested by ICAC many times, and every year I was required to remove my shoelaces for fear I would commit suicide. Of course, I won't allow him to do so. I said, you have your shoes on. And he kept abusing me with foul language. He said that ICAC has arrested me so many times, but I've never been prosecuted. I want to complain against you. Well, it's a fact that he was arrested by ICAC many times without any successful prosecution. There was not even an attempt to prosecute him because there wasn't sufficient evidence to charge him. But does that mean that there was no bid rigging? For sure not. How come people like him can be free? Because he has behind him a group of lawyers, professionals, and also corrupt members of OCs, so on and so forth. They have organized themselves into highly organized big rigging syndicates to suck money out of property owners. Bid rigging has been so rampant, and the government cannot shirk its responsibility. For so many years, the government has forced property owners to maintain their properties. There's nothing wrong in that, but you must monitor the situation. The market is close to $10 to $20 billion per year. We talk about hundreds of billions, tens of billions of dollars in profits, given that this is so much profit to make. And bid rigging syndicates are looking for praise, and yet the government has acted like an ostrich. It has buried its head in sand and turned a blind eye to the loopholes. There are many loopholes in the Buildings Management Ordinance, and therefore bid rigging syndicates are controlling proxies and also OCs trying to influence voting in AGMs of owners. As a result, many suspicious bid rigging bids have been passed. And then departments are responsible for law enforcement. Well, there are many of them: ICAC, the police, HAD, and the buildings department, the competition commission, and also the home district officers, numerous. These departments only look after their own business. There is no concerted efforts to crack down on bid rigging. In recent years, there are more and more such syndicates. They are growing bigger and bigger and profiteering, undermining the interests of property owners. Some property owners are elderly persons. What they have left of their savings is just their property they live in. They do not have a lot of savings left, and a maintenance exercise can cause them hundreds of thousands of dollars. Their grown-up children may not be helped, so they have to remortgage their property to contribute to a maintenance fund. The high maintenance cost has caused property owners and elderly persons to exhaust their money saved up for their, so to speak, future funeral. And even for middle-class property owners and those living in luxury flats are severely undermined because of bid rigging. There is a property owner who lives in a flatted apartment in mid-levels. His flat size is 3,000 square feet, and he has to contribute $350,000 in external wall maintenance. How come a unit has to spend $750,000 on maintenance of the external wall of a flat? Are they paving the external wall with gold? People who live in luxury flats may be from higher income bracket, but they find that rather unfair. You can easily pay over $700,000 for one RMP exercise, and this is so unfair. Faced with this serious problem, the government a few years back even denied the existence of such a problem. 3 years or so ago, for the first time, I exposed the seriousness of this matter to the media. The media asked me, well, Lam Cheuk-ting, I trust your words, but can you show us some documents? I said, I'm sorry. All documents are with the ICAC. I don't even have a page. If you trust me, report it, cover this. If not, there is nothing I can do. Eventually, the incident was covered by the media, and then many cases approached me, and we set up an alliance to combat bid rigging. We organized property owners together so as to expose bid rigging syndicates. We keep educating the public. We keep exposing the dark secrets of this industry and their malpractices. There are professionals and building management companies involved, and there are also triads behind them. We have tried to right this distorted market using civilian efforts, but what we can do is far too little. Our alliance has assisted hundreds of residential developments. We have vetoed projects up to hundreds of or tens of billions of dollars. But you should not just rely on this alliance to counter these expensive projects. The government is in control of a lot of resources to assist property owners. With a persistent effort, a few years back, the government started to admit that there was the problem of bid rigging. Gradually, it tried to respond to our aspirations. It's now reviewing the buildings management ordinance, hoping to crack down on bid rigging. And URA has got a scheme, and the police has also got a scheme to help to tackle triads who are parties to bid rigging. The Competition Commission has also conducted an in-depth study in bid rigging activities. However, the problem is still unresolved. Many property owners are losing hundreds of thousands of dollars in maintenance of their buildings. As I said, the market is worth tens of billions of dollars. Every year, triad-led bid rigging syndicates are making profits up to tens of billions of dollars. They are not fattened, and they are powerful and influential. They have triads to help. They have lawyers to help. And if individual property owners come out to protest, they will be subject to great pressure. A few years ago, I exposed this problem. I've assisted many residential developments to suffer great loss in bid rigging. I was once warned to be careful of my own safety. That warning was made out of goodwill. Starting from then, I've been carrying a backpack with me every time I go out, so that it can at least shield me from a few steps. So now I have put down my backpack, because even if the attack LAM Cheuk-ting is useless, property owners are now awakened to this danger. And even if you stab LAM Cheuk-ting, is useless, because property owners know that the whole society must stand united to say no to bid rigging. I urge members to support my motion. I now put a question to you, and that is the motion moved by Mr. LAM Cheuk-ting be passed. For members who move amendments to this motion, this council will conduct a joint debate on the motion and the amendments. I will call upon members who move the amendments to speak in the following order: Mr. LAU Kwok-fan, Mr. Alvin YEUNG, Dr. Fernando CHEUNG, and Mr. KWOK Wai-keung, but they may not move amendments at this stage. The Honourable LAU Kwok-fan.
主席，根據市建局咧。
Madam Deputy, according to URA's study, in Hong Kong there are 21,000 buildings that 30 years old or more. There are 3,000 or so that need to be renovated, and the cost can be more than $100 million. The maintenance market is really a fat piece of meat. It would be a magnet for a lot of bid rigging syndicates. There are so many bid rigging contracts, $260,000 for garden and garden vista, and indeed the bid rigging situation is very serious, and the government should be held responsible to a certain extent. There are some said that the syndicates are very skillful. They do have the tacit understanding with the owners' corporations. They'll be colluding with triads, the owners' corporations, to dominate the market. Even with the establishment of the Competition Commission, it doesn't make any difference to the situation. The syndicates are becoming more professional, and they are engaging in their acts in a more secretive manner. In recent years, there are more and more buildings with owners' corporations where the government's support is lacking. The HAD should send liaison officers to attend the overseas meetings, but since there are more and more renovation going on, the HAD is understaffed, and inexperienced staff are sent to these meetings. According to the residents, if there are tricky problems, the community organizers or the liaison officers would be unable to handle them. When they attend the owners' meetings, they do not offer much in the way of advice, and it would just refer them to relevant departments. Madam Deputy, in order to make available support, the DAB has offered a lot of assistance to the overseas. We have set up the 344 concerned group. We have received a lot of requests for assistance. We provide assistance to them and offer them better knowledge about CAP 344. And we foster better communication among the owners and enhance trust. And the owners should be concerned about the building affairs. From our cases, there are some that involve bid rigging, and there are some illegal acts involved. We are concerned. We attach a great deal of importance to this. We get in touch with departments for them to offer help. There are certain cases where there is a lack of communication between owners and the owners' corporations. we tend to receive complaints from the owners that they are victims of bid rigging, because when it comes to renovation, it involves a huge sum of money, and however hard the owners' corporations try to persuade them, there would normally be disputes arising from that. This is filling them with concerns. They have to face the prospect of bid rigging, and also they don't get the support from the administration. There are certain projects that are urgent. In particular, in recent years, there are urgent renovations that have to be undertaken, and the owners' corporations may be queried by the small owners about the possibility of bid rigging. And the harmony will be undermined in the housing estates, and there are some owners' corporations that are accused of bid rigging, and they would from time to time ask for a replacement of the owners' committee. I hope that there would be better communication between the owners and the owners' corporations, because otherwise it will be a lose-lose situation. In many cases, they could engage each other in communication, but they end up in court, and they will be fighting each other in court, and this is a lose-lose situation. I've got a couple of suggestions to make, Madam Deputy. There is the smart tender, and also the assistance scheme offered by the URA, and a lot more information is made available. But under the smart tender scheme, this would happen at the successful tender stage, and thereafter the owners will have to follow up on the proceedings. If the quality leaves something to be desired, then the owners will have to follow up, and this is not going far enough. The scope of smart tender should be extended to cover the supervision of the work and the final acceptance of the end product in order to ensure protection. Owners or the residents don't have any recourse if they encounter problems, and the departments concerned are very much like silos. So we think that the police, ICAC, HAD should come together to form a works authority and offer professional advice to the residents, and there would be a reliable platform for the residents. Third, many residents told us that some undesirable elements would collect proxies from the residents in order to manipulate the owners' corporations. It is well documented in the newspapers. Under the Prevention of Bribery Ordinance, it doesn't catch this kind of scenario, and the government doesn't seem to be facing up to this. The HAB has amended the CAP 344, but it hasn't gone far enough to look at this. So in the consultation period, we did offer our advice to the HAB and hope that they would improve the amendment. There shouldn't be any collection of proxies to manipulate the situation, because this will avoid a situation where the undesirable elements will manipulate the situation. The HAD is really understaffed, and I hope that there would be more staff and that would be added to improve the quality of service. And the liaison officers can focus their attention on building management, and they don't have to be doubling up doing other duties. And the liaison officers should be better equipped to deal with all manner of building management problems. It is important to have more resources for the HAB. It is very much the HAB deals with this issue, and they would take on board our advice and make improvements, in particular the proxy, the content of the proxies. They have taken into account our views, and also the record keeping period. There should be, however, more manpower resources to supervise the work. It is everybody's hope to have a decent accommodation. The bid rigging is undermining social mores, and this is something that cannot be accepted. I hope that the administration would unite every sector in the community to tackle bid rigging in a way that the small owners will not be squeezed. In Mr. Lam's original motion, Mr. Alvin YEUNG, Dr. Fernando CHEUNG, Mr. KWOK Wai-keung's amendments are all intended to plug the loopholes in the Buildings Management Ordinance, and there should be an authority to be set up to provide professional support and also to step up enforcement actions. I'm sure that all these will go a long way towards tackling bid rigging. We very much hope that the administration would redouble their efforts, and everybody in the community should join hands to tackle this problem. The DAB will also support this idea. With these words, I conclude my speech.
The Honorable Alvin YEUNG. Thank you, Madam Deputy. In the past 5 years, property prices have gone up by almost 60%. Anyone who can become a property owner, well, you want to congratulate him. But does that mean that once you are a property owner, you can feel secure? Of course not. In particular, for property owners who have owned their flats for decades, the mandatory building inspection scheme is a time bomb, because they constantly fear that they have to pay hundreds of thousands of dollars in maintenance. According to the government, in 2015, there are about 5,900 buildings that are over 50 years old. And this is going to grow by 180 per year. For those over 30 years old, we have close to 20,000 of them. It's expected that by 2025, the figure will grow to 30,000. Among these 30,000 blocks, we have many property owners who spend their lifelong savings to buy a small 600, 700 square foot unit. And all of a sudden, they face a maintenance bill of tens of hundreds of thousands of dollars. This is tremendous pressure. It all goes back to 2016 when the mandatory building inspection scheme MBIS was launched. Of course, the rationale behind is owners should be responsible for the condition of their own buildings, and older buildings should be subject to inspection. And for some residential developments, for fear of escalation in maintenance costs, even though their turn has not come up, they would take preventive measures in maintaining or carrying out maintenance works first. The side effect is many contractors use that as an opportunity to profiteer, and that is the cause of bid rigging. Well, bid rigging very often starts from smaller projects. We have so-called OC rats. These are people who have encountered them when I served the community. They bought 1 or 2 small units in residential developments that are already 20, 30 years old. So as property owners, they would seek to become members of the OC. Not many people in Hong Kong like to be office bearers of OCs, and these people will manipulate this chance. They would even collude with contractors and consultants to help them to successfully get maintenance contract at prices much higher than the market rate. This goes to show that regulation is needed for the building maintenance market. The Civic Party asked that the maintenance Building Maintenance Works Authority be set up to introduce a registration system for building maintenance and to mandate consultants and contractors to be registered before they can take on such projects. And the authority should be given a statutory duty to monitor maintenance projects. They can even impose sanctions on offending consultants and contractors, such as an open reprimand or revocation of licenses. This will be a deterrent to black sheep of the industry. And then members of the public will have access to information on who are the trustworthy contractors and consultants to help them make a decision. We have also got the Building Maintenance Ordinance, Cap 333, and it's relevant to all property owners in Hong Kong. Well, the ordinance itself is flawed with a lot of loopholes. Of course, HAD is undertaking a review of the building. But the proposal from the HAD is a far cry from our ideal. We hope that in this long review exercise, the administration can consider more progressive means to amend the legislation. For instance, guidelines for proxies with the following suggestions. 48 hours before an AGM is to be held, a list should be posted at conspicuous places of the development units that have appointed proxies should be on the list. And for those owing 5% of the shares or those holding proxies equivalent to more than 5% of the shares in the development should also be published, so the property owners will know whether, without their knowing, they have already appointed a proxy. And then they will also be able to tell who is in control of big shares of the development. If they're people they know and trustworthy, that's fine. If not, they can become wary and keep a close eye on the conduct of such people. In addition to the loopholes in the appointment of a proxy, I hope that the threshold for convening an AGM to deal with the relevant project should be increased from 10 to 20%. This will ensure that more property owners can take care of their own properties and to encourage them to join AGMs more often. And this is a measure to prevent bid rigging. We'd like to raise the threshold for the quorum of an AGM with good intention. Some owners may fear that it will be more difficult to convene AGMs as a result. I'd like to remind owners, if you are careful, if you want to guard your wallet, I think you won't mind the raising of this threshold. And we also like to introduce a cooling off period. Now, when you take out insurance products and cosmetic products, there are cooling off periods. We are talking about hundreds of thousands of dollars per unit for such a project. So it for sure warrants a cooling off period so that after an AGM, then property owners can then cool down and reconsider whether it is a worthwhile project. And this will help to prevent many disputes. Another problem which has caused troubles to property owners operation of the lands department. Now, when you want to sue the OC, of course, you have to spend your own money to file a case. And OC in defense is also using money from me because as a property owner I have to pay management fees, and OCs can use the management fees to defend themselves in the lawsuit. Therefore, people are not really inclined to sue the OC. I hope that the Lands Tribunal can set up a mediation mechanism for former judges to chair a mediation. Yes, this proposal from the HAB is a good one, but I hope that the Lands Tribunal can set up a tribunal for building management. Well, there is no need for legal representative. It's just like the minor claims tribunal or the small claims tribunal. This will be less expensive, and perhaps we should discuss with the judiciary so that Lands Tribunal has more resources by shortening the filing time. Then property owners can have recourse to justice sooner, because very often they have to wait for years and months before a case is heard, and this is very unfair to property owners. I hope that downstream we can use these measures to help property owners. I know it's not easy to amend Cap 344, but with all the good intention of the community, of the administration, LegCo is willing to cooperate. After all, we talk about protecting the rights and also money of hundreds of thousands of property owners in Hong Kong.
Dr. Fernando CHEUNG, many Hong Kong people use their life savings through accumulated through years of hard work on the property they own. This is just typical of Hong Kong people. If you own your home, you enjoy better safeguards, given that rent is rising so quickly and property prices too. If when you get old and you own a home, you can enjoy some sort of security. But to many elderly people and their families, when the property ages, the maintenance and repair will be required, and hence they are nightmare. Because if a bid rigging is involved, then they will have to pay through the nose for the building maintenance bill. Many of them do not have a lot of savings. They only got a meager sum to eke out the years. And if suddenly you want them to pay tens of thousands of dollars or even hundreds of thousands of dollars, you are actually killing them. I know many elderly property owners are very distressed when they have to do this. And some have fallen sick. And some even pass away because of the stress. I've heard from owners, corporations, that the property owner passed away while dealing with such a situation. And there's no reason that the government should ignore them. There are many cases of bid rigging. I would like to talk about a case in Tsuen Wan called Kwok Wai. The maintenance works was only completed 10 years ago, and then the consultant was engaged at a low cost. Very scant details were given, and the quota price is much higher than the one suggested by the housing department. The proposal was voted down, but then last year they proposed this again, and the OC, through an election, was replaced by the owners. But the original OC then, surprisingly, refused to hand over the accounts. And in April this year, the bank account of the OC was frozen, and therefore they owed millions of dollars in payment to the cleansing and security contractors. So all these management work came to a halt, and some of the contractors cut down on the service level, including caning work. So this OC can act in such a outrageous way. The new OCs sought help from the government, but they were frustrated. The previous OC blatantly breached the law, but the HAB can only provide mediation service. The new OC chairman laments that property owners' interests are not protected by anyone. And one of Mr. Wong said that the HAD could do nothing about the previous OC, and when they have meetings, only very junior officials were sent to attend those meetings by the HAD. When the new OC wanted to take over the accounts and to lift the freeze on the account, well, the OC took the previous OC to the court and they won, but they spent $1 million, more than $1 million on the lawsuit. And that's the painful experience as referred to by Mr. Alvin YEUNG. You are spending your money to fight the previous OC, which means that you also spend money for both sides. Today, I'm grateful to Mr. LAM Cheuk-ting for moving this motion to talk about bid rigging. This gives us an opportunity to look at this loophole riddle, the CAP 344. We should ask for immediate amendments to the ordinance. The relevant sanctions and punishments should be enhanced, and the roles and responsibility of different departments should be delineated, and there should be a further arrangement for a cooling off period. If the cost of the maintenance work is $1 million or accounts for 30% of the budget of the OC, there should be a cooling off period of 1 month. And Mr. Alvin YEUNG has also proposed to raise the quorum of owner corporations meetings. This improved system for the tendering should be introduced as soon as possible, and the assistance offered to OCs to be extended to more old buildings. I support every amendments and the original motion. Small property owners, especially those who are elderly people, have to suffer a lot of because of the scares caused by bid rigging. I understand that some old buildings have to be redeveloped, but I hope in the May that we'll go for maintenance, and our community should help these building owners to upgrade their buildings so that the living environment is commensurate with our economic development levels. On this issue, and that is on the common position of anti-bid rigging and the need to amend the building management ordinance, as well as assistance rendered to owners to prevent bid rigging. There's any difference of opinion. I hope this motion can be carried, and the amendments too, and I hope that after that the government would come up with a positive response. In the past, even when the motions were passed by this council, the government would be very slow in reacting, or adopted a very sloppy attitude, saying that they had noted the views expressed, but the established system was considered effective. Prevention of bid rigging and punishing those guilty of bid rigging should be an urgent matter. Although the current government is about to step down, but it seems that Mr. LAU Kwok-fan is going to continue to serve in the next government. Very rarely do we have such a consensus in this council. We should not allow bid rigging to continue. Otherwise, Hong Kong will become a backward city. We should not allow a small number of building owners to collude with trial societies as well as unscrupulous professional consultants to join hands to cheat and to swindle the property owners of their money. So I submit.
The Honourable KWOK Wai-keung. Thank you, Madam Deputy. Hong Kong has reached the stage when you own a flat, you are worried, and if you don't, you are also worried. For those who are not flat owners, they worry whether they can afford a flat. For those, they are worried of possible bid rigging in maintenance exercise. The MBIS was implemented in 2012. So for buildings over 50 years old, 20 years old, there must be a major inspection every 10 years. So a registered contractor will be employed to check the external wall, the signboards, and also protruding articles. Well, the law is well-intentioned so as to avoid accidents associated with poor maintenance, but because of insufficient monitoring of bid rigging, property owners are really worried. And there are people out there who equate maintenance with bid rigging. So whenever they think of maintenance, they suffer headache. I'm worried that if we do not do something to tackle this, expensive bid rigging will not be news. Now, for typo, a tie was say $170 million and a dragon court, so on and so forth. Each unit was required to spend a few tens of thousands or even $100,000. Well, HAD will not take any action. The police will not accept such cases, and ICAC takes a long time in investigation. And if they go to the court with the OC, again, they will suffer. Bid rigging is one of the major targets of enforcement in the Competition Commission. And the ordinance took effect. And then 2017, you may think that this is finally a solution, but in fact, investigation is extremely difficult. Even Mr. LAM Cheuk-ting, who once served in the ICAC, told us that a person has been arrested a number of times, but no prosecution could be taken. So it was not until March when the Competition Commission sued or prosecuted 5 IT companies for bid rigging. Yet, no single prosecution has been instituted for bid rigging so far. And what is most worrying, bid rigging very often involves the control of triad elements behind the scene. So when property owners have a query, the bids, so well, their keyholes may be blocked, and that's the latest. And when it's most severe, their personal safety is at risk. But for property owners, they are in a very difficult position. They cannot sell and leave their flats, and for the lawbreakers, they know where you live. In the past, people robbed and snatched, but that was very risky. But now bid rigging can help you to profiteer and is very low risk. ULA provides a smart tender smart scheme to help OCs to employ independent professionals to help to assess and examine tenders and so forth. So it will help to analyze reports and provide professional independent advice. UA will also provide an e-platform for calling tenders so that OCs can employ contractors and registered accountants to examine tenders. URA's measures can help OCs and ICs and separating the tender for employing a contractor and a consultant also helps so that property owners will not be so easily ripped off. However, the scheme itself is not enough. It can only benefit a limited number of property owners, and it's also paid service. So I suggest that we set up a one-stop maintenance information database. All information related to maintenance projects should be included in the database, including costs and also records. And if such data is published, then OCs can check the prices and try to understand whether a particular company tends to submit higher bids together with another consultant. They can also tell whether the relations between two companies are particularly suspicious. Then members of the public can beware, and there is also revenue for complaint. Because the database is such that after each maintenance exercise, a report is required, whether it be the price, the quality of works, the progress, so on and so forth will be included in the marking. Because as we all know, some projects may expect that it can be completed in half a year, but it may take up to 3 years as a result. Our speculation is that at first, the consultant cannot come to an agreement with the contractor. And of course, the consultant will be very strict. And then when the two has come to an agreement, then even for works uncompleted, the consultant may still sign, may still endorse the reports. So if we can have a system for marking the performance of consumers, for contractors and consultants, then it will be good, so that property owners will not be at the mercy of these unscrupulous people. For those who have done well, the information platform will serve as advertisements. For those who have done poorly, then other OCs can be warned. Even a long time ago, after you have asked for tribunal be set up to handle building affairs, so that for building works related disputes involving corruption and bribery can be handled by this tribunal. Because parties to the tribunal need not be legally represented, and this will greatly reduce the costs and lower the burden on property owners. My amendment has scrapped the first sentence of the original motion, and that is monopoly by bid rigging syndicates involving triad members. The reason why I've scrapped this sentence is, for sure, in some cases, triad elements were involved, but there are many contractors who do not have any triad background. But because of intimidation or threat from these triad elements, they may be forced to adjust their bids, and then they may allocate the different catchment areas for different contractors. This would affect the normal operation of the industry. And so I have scrapped the first sentence, and I have changed it to law-breaking syndicates or crime syndicates. More and more people have their eyes on the fund. They know that there is a maintenance fund set up, and so they become office bearers of the OCs so that they can split the maintenance fund among themselves. So this is also a headache for many. Hong Kong has the rule of law. We should not allow syndicates to do what they want. Therefore, the government must assist property owners and OCs to tackle and punish bid rigging syndicates. The Competition Commission as well as the ICAC must act expeditiously to take prevention. And the work of the Commission is one of prevention. However, it should step up its efforts. And it should help to establish a one-stop maintenance information platform and database so that the public can be informed. Thank you.
Secretary for Home Affairs. Madam Deputy, the government attaches great importance to the community's concerns over suspected bid rigging activities on building maintenance projects. I'm grateful to Mr. LAM Cheuk-ting for moving this motion, as well as Mr. Edward Lau, Mr. Alvin YEUNG, Dr. Fernando CHEUNG, Mr. KWOK Wai-keung for moving amendments so that the Secretary for Development and myself have this opportunity to exchange views with members on this issue. In fact, apart from the Development Bureau and the Home Affairs Bureau, all government relevant departments and organizations, including the Hong Kong Police Force, ICAC Competition Commission, the Urban Renewal Authority, the Hong Kong Housing Society, and the Home Affairs Department, have all been fully cooperating with different sectors of the community and taking a multi-pronged approach to prevent and combat bid rigging. Bid rigging is the reason of bid rigging is complex. It involves tendering, quotation, and work supervision. To effectively prevent and combat the unscrupulous from making profit from tendering, bid rigging in maintenance projects, we must take targeted strategy and work on enforcement, professional support, publicity, and education to provide appropriate support for owners. The government has been providing legal framework through the Building Maintenance Ordinance BMO to assist owners in properly managing their buildings. The Home Affairs Department also provides appropriate support to owners' corporations and owners. Along with publicity and education, we strive to assist owners of private buildings to fulfill their responsibility of managing their buildings. We hope that through raising the concern of OCs and owners on building maintenance, we can encourage owners to participate in the process to safeguard their rights and reduce disputes, and also minimize the chance of works being manipulated, and to provide referral service and advice to members where necessary. And to address the public's concern on building management, especially disputes arising from large-scale building maintenance, we reported our review of the BMO in May 2016 to the panel on Home Affairs, and following that in March this year, we also consulted the panel on the relevant legislative proposal and the administrative measures covering procurement and large-scale maintenance projects, appointment of proxy, proper safekeeping and circulation of records, accounts and financial statements, non-performance of MCs, and power of the authority, criminal sanction, technical amendments, etc. We hope that through raising the enhancing the transparency of arranging for building maintenance works and also enhancing the participation of owners, we can minimize the chance of the project being rigged by the unscrupulous, so as to reduce disputes arising from large-scale maintenance projects among owners, corporation, and PMCs. As it takes time to amend the ordinance, we are going to put proposals that are not in conflict with the existing building maintenance ordinance in the code of practice to address the public's concerns as soon as possible. OCs will be encouraged to adopt these proposals. On support for OCs and owners, as the three without buildings may face more difficulties in preparing for maintenance, the HAD has rolled out the Building Maintenance Professional Advisory Service Scheme, which is now in the third phase. And under the scheme, we engage property management companies to provide free professional support service to owners of old buildings with which are over 30 years with low rental value, including assisting them to form OCs, improving building management, preparing for maintenance works, and applying for assistance. In April, we introduced a pre-meeting advisory scheme for OCs to enhance support for the OCs. The target service users are newly formed OCs, new term OCs, and OC meetings with expected dispute items. Under this new service, the district building management liaison teams of the district offices will explain before the meeting to MCs and OCs the meeting procedure and offer advice. As at the end of May, the district office has already organized over 600 advisory sessions. And if there is any dispute arising from the OC meetings and the building maintenance project, the district office will also strive to mediate the matter and also explain the various professional advisory service to owners and OCs, including free legal advisory service for building maintenance, panel of advisors on building management disputes, and free mediation service for building management, so that professionals who are neutral can offer free professional advice to owners, or recognized or qualified mediators can provide the pro bono mediation service to resolve dispute. And also, to address the concern on resolving disputes through the Lands Tribunal and the cost and time involved, the Home Affairs Department in March this year proposed to roll out the free mediation service scheme for or the Building Management Dispute Resolution Service, which will run as a pilot for 2 years. One retired judge would be appointed to provide neutral and authoritative advice for free for OCs and owners to assist them in resolving disputes over building management without going through the expensive legal procedures. On publicity and education, last May we published the guidelines on proxy for the general proxy for the general meeting of an OC, and guidelines on procurement process of an OC, including the appointment of proxy and the best practices of proxy and procurement procedures. We encourage the OCs to adopt the guidelines. We also have systematic training courses to enhance the capability of OCs in building management and maintenance matters. We also work with the Buildings Department, the Police, ICAC, URA, Housing Society, and the relevant professional institutes in various seminars, workshops, and talks on a regular basis on building management and building maintenance. And we also assist the relevant organizations in distributing publicity materials to owners and owners corporations on the latest news on crime prevention and corruption prevention. We also maintain close liaison with OCs and owners who intend to go through building management. We encourage owners to participate in the process, especially at the preparation stage, to get an understanding at an early stage about the maintenance project, and to actively participate in general meetings to avoid disputes or illegal activities. If necessary, the district office can also refer them to take part in various professional support service schemes provided by organizations and professional groups, such as the Smart Tender Scheme of the URA. To enhance publicity and education, the Home Affairs Department during Chinese New Year introduced a new round of APIs and posters to encourage owners to safeguard their rights and to actively participate in OC meetings, and they should participate in person instead of appointing proxies. The APIs has begun to be broadcast in the end of March with the slogan "Active participation in building management benefits all," which is key to building management. Mr. President, the government attaches great importance to combating bid rigging, and we keep all options open in listening to the views of the community on how this issue should be handled. We will also roll out new measures at appropriate times to combat bid rigging, and I will give my response later after hearing from members.
Secretary for Development. Madam Deputy, as the Secretary for Home Affairs pointed out, the administration attaches a lot of importance on suspected bid rigging in building maintenance projects. Just now, the Secretary of Home Affairs has already spoken to members about relevant work under the Buildings Management Ordinance, publicity, public education, and also under the HAB and the Home Affairs Department. Before I listen to members' speeches, I would like to quickly go through the work under different departments to combat bid rigging, and also the technical support given by the Development Bureau and the Urban Renewal Authority URA for private building owners on maintenance and repair. The definition of bid rigging is that two or more tenderers that are supposed to compete with one another will get together and form a secret agreement to agree not to compete so that they can get a particular project. Bid rigging in relation to building maintenance and repair is a very complicated matter. Apart from anti-competition behavior, it may also involve project consultant, contractors, property management companies, owners corporations conspiring together to decide who will get the contract in order to obtain some gains. It may also involve corruption and also triads. In relation to the various offences related to bid rigging, there are three law enforcement agencies mainly. The first one is the Competition Commission. Under the Competition Ordinance, it stipulates that an undertaking is prohibited from entering or enforcing an agreement that prevents, restricts, or distorts competition in Hong Kong. Under the ordinance, bid rigging is a serious anti-competition behavior. So combating this is the Commission's main focus. The second one is the ICAC. It enforces the law in relation to corruption related to bid rigging. Seeing that the number of complaints related to corruption in the maintenance and repair of buildings, the ICAC set up a nine people dedicated team in April 2015 to focus on the investigation of corruption related complaints in this area. The third one is the police. They will focus on the law enforcement on criminal behaviors as, say, for example, triad involvement and also violence. The administration has always emphasized that maintaining and repairing private buildings is the responsibility of owners. Notwithstanding, the government understands that for some owners, they don't have the experience and professional knowledge. They may feel that they are at a loss and worry that the project will be used by malefactors. As a result, the URA launched, we're using their own resources in May 2016, Smart Tender Building Rehabilitation Facilitation Service. Under the scheme, eligible owners corporation may receive technical support and professional advice in relation to engaging contractors in the repair, maintenance, or project. Under the Smart Tender Scheme, the URA will provide a DIY toolkit to owners corporation in buildings with 3 floors and above to guide them in organizing the work, giving them tips to reduce risks of bid rigging. The URA will also arrange a third-party independent professional to provide advice, including budget of the project, so that they can make reference of it. Well, in the end, this scheme will provide an electronic platform to provide information about the tendering process. And currently, there are about 200 of such interested contractors registered on it. Under the smart tender scheme, the charges ranges from $25,000 to $160,000. But we consider that owners may need assistance, so the government will inject $300 million to help owners participate in it. So the fees will be driven down to between $1,250 to $80,000. We reckon 90% of owners in buildings over 30 years old will only have to pay $1,250 to $30,000 to participate in the scheme. It will be launched in the second quarter. I'll pause here to listen to members. Thank you.
Dr. Lau Kwok. Well, in terms of stepping up the regulation of building maintenance projects, well, last time there were two motion. In the last term there were two motion debates on the same topic. In relation to Mr. Lam Cheuk-ting's motion and the 4 amendments moved by members, I think in principle they should be supported. The building stock of Hong Kong is aging rapidly, and there are about 20,000 buildings which are aged 30 years or above, and in 10 years' time it will increase to 30,000. According to 2030 Plus, a vision transcending 2030 consultation document, by 2046, private building units that are over 70 years of age will reach 326,000, far exceeding the figure in 2015, up by 30%. In 2009, the government launched the Operation Building Bright project to provide assistance and professional support to owners, involving a fund of $3.5 billion, subsidizing 3,200 buildings which are 30 years or above in their maintenance project. The government also introduced in 2012, in June, the mandatory building inspection scheme. Some buildings would be chosen as target buildings for mandatory inspection and maintenance, and through mandatory building maintenance assistance scheme, it provides financial assistance to needy owners. This, of course, addresses the concern on building management and safety. Building management project often involves large sums, and it's also the target of unscrupulous syndicates. In recent years, we have seen more and more disputes over building maintenance, and sometimes the bidder winning the tender may quote a price that far exceeds the market rate. But to suggest that building maintenance works in Hong Kong have been monopolized by bid-rigging syndicates involving triad members, the views are divergent. In particular, the views of the industry. There may be unscrupulous operators, and some construction companies have therefore decided not to participate in these projects. And there are also developers and contractors being involved in corruption. I believe in the law, and the culprit will be brought to justice. Building maintenance works is a complex issue. It involves a lot of stakeholders, including owners, OCs, management, property management company, engineering company, or contractors, and we should take a targeted approach, therefore, because at the same time we need to step up regulation and safeguard the rights of owner whilst maintaining flexibility so that a level playing field can be provided for the industry. The competition ordinance took effect in 2015, and bid rigging is considered a serious breach of the competition law. In May last year, the Competition Commission published a report on study into aspects of the market for residential building renovation and maintenance, which addresses the concern of bid rigging in the sector, and also provide reference for the government's work in the future. The point is that in terms of support for owners cooperation, and the PMCs, there is insufficient support. Although the government encourages building owners to set up overseas, there are still some 6,003 without buildings which are unable to form overseas and engage a PMC. In March this year, the administration briefed the HA panel on review of the BMO Cap 344 regarding the further legislative proposals and administrative measures, including raising the quorum and the percentage of votes at OC meetings and definition of large-scale maintenance projects. I think on these topics, a pragmatic approach should be taken in terms of, and a balance should be struck between the representativeness of OCs and the building maintenance works. To encourage members of the public to take part in building maintenance and management, the URA and the government have launched different assistance schemes, for example, building maintenance safety loan scheme and other financial assistance schemes to provide financial support to owners. And the age limit of the buildings should be relaxed so that more owners can benefit from the schemes. At the same time, since May last year, the URA launched the Smart Tender Scheme for building rehabilitation to assist owners in providing professional support and advice on building maintenance. In this year's budget, the government announced that $300 million will be reserved for small owners to take part in the scheme, and it is expected that 4,500 buildings will benefit from the scheme. In other words, the different professional institutions in 2014 and 2016 provided or operated a pilot scheme on EC Building Maintenance Advisory Service Scheme. At the moment, the government already has a website to provide information and support to owners on building maintenance, but I think that the government should work with stakeholders along with law enforcement agencies, professionals, and also contractors to provide a one-stop service platform to help owners address issues surrounding building maintenance and to enhance transparency of projects. Some members suggest a building maintenance authority should be set up. I have reservations because the competition ordinance has been enacted and the BMO will soon be amended. The administration should be able to deal with the issues according to the existing framework, and there is no need to set up a separate authority.
Mr. Lang Yeung. Madam Deputy, Mr. Lam Cheuk-ting moves this motion. I fully support it because in recent years we have a more and more serious problem of aging buildings. So the maintenance market is huge. Everyone wants a slice of it. Well, there may be a chance of bid rigging, and on top of that, we see that quality is not guaranteed, and project price may be astronomical. Well, bid rigging may involve, or building repairs may involve owners, corporations, management companies, and sometimes triads. So small owners may not be able to do anything about it. So we do need assistance from the government. The biggest problem is that the Buildings Management Ordinance (BMO) is littered with flaws. It is a toothless tiger because the BMO only provides a legal framework for owners to work together to fulfill their responsibility to manage the building. So the government only assists in management and repair. The Home Affairs Department will only act as an intermediate. There may be penalties set down, but it's rarely enforced. There are a number of provisions that carries penalties. Say, for example, submitting false documents, failure to provide a financial statement to the OC within a certain time, or failure to take out a third-party insurance. However, these provisions are unclear, and although there are penalties, they are not enforced. The governments always focus only on advisory and mediation. Looking in the records, the HAB said that between year 2004 and 2011, they have received dozens of reports about owners corporation OCs breaching regulations and rules. However, there has never been any prosecution because they said they have to be very careful. They don't want to drive a wedge amongst the owners, so they would like to resort to an advisory or mediation role. So the government is empowered to take action, but they refrain from doing so. And some people told me that when they make a report of breaches by OCs, the OCs are only reminded to abide by the law, or owners are asked to take out a lawsuit from the Lands Tribunal. They have forgotten that small owners don't have the resources or time to deal with long drag-out in litigations. So OCs are can get away scot-free. Why is it that there are powers that are not used? I remember with the previous Home Affairs Bureau Secretary, I said that, well, in the case of failure of submitting financial statements, well, a report was lodged, but nothing was done. So the small owner took the case to court and lost the case and had to pay hundreds of thousands of dollars. And still, the HAB said that it has to be carefully dealt with and refrain from providing any assistance. The HAB said that when they receive complaints and when there are elements of illegal activities, say for example bid rigging, what do? Just like the secretary said, that well, complainants are encouraged to complain to the Competition Commission or make a report to the ICAC or the police. Sometimes they are advised to file a case with the Lands Tribunal, but nothing works. To put it simply, say for example, proxies in a general meeting. Sometimes false proxies are signed for people to attend the meeting, and then, well, it's very obvious that that's a falsely created proxy. But when you report to the police said, do you have any evidence? Otherwise, we won't be able to follow it up. The administration kept saying that they would refer the cases to law enforcement agencies. What's the successful rate? Last year, it accounted for 22% of the overall number of complaints. So the HAD is responsible for enforcing the BMO. They act only as a mediator. They just, they don't want to take sides, and they can't protect the rights of small owners. This is a serious problem. The two secretaries said that the URA would provide support. There is a case in Hong Kong. It's a building under the Operation Building Bright. They approached the URA for assistance, and they said, well, I'll give you a list. And if there's not enough, I'll give you more lists. And that is technical support. Don't you find it unpalatable? Because it's of no real use. So when it comes to bid rigging, sometimes it's not a problem with the OC or a problem with contractors. The government fails to properly manage and monitor the situation. When they receive report, well, for the ICAC, when you make a report to them, they ask you for evidence. If without any evidence, we will not follow up. So it's a waste of time. People are not in a position to gather evidence. That's why they approach law enforcement agencies. And instead, they are asked to provide the evidence. What's the point of referring these cases? So if we rely on the government for referral to the right department is only passing the buck because they have failed to register the seriousness of the problem and they don't have the heart to help small owners. The administration should find more ways to help small owners to fight bid rigging. They should not just keep shifting responsibility and talking nonsense out of their head that they will follow up.
Mr. Wilson Ong. Thank you, Madam Deputy. I support the motion to tackle bid rigging. I also support all the other proposed amendments. In 2015, the URA carried out a survey. There were 21,000 buildings that had a history of more than 30 years. By 2049, there will be an addition of 40,000. And then we need to carry out a mandatory building inspection once every 30 years. In other words, every year on average, 3,000 buildings have to carry out renovation works. Well, buildings are aging and the government has launched a number of schemes. Building management is a market which is growing. Now, for older buildings, when they need to be renovated and repaired, the sum of money involved is astronomical. So bid rigging has been carried out so as to exploit the market. As has been pointed out, the market is a lucrative one, and so bid rigging means that there is manipulative activity affecting the fairness. Sometimes owners may approach the ICAC for help. The lack of evidence means that they have not been convicted. The huge renovation cost jeopardizes the interests of the small landowners and it obstructs the work of the owners' corporations. We need to take action. Therefore, I'm trying to come up with some recommendations. The DAB has already provided a lot of suggestions, and administration is now consulting the public on a number of them. In March this year, eventually, we get some proposals from the HAB so as to amend the building management ordinance so as to tackle the question of bid rigging. We do welcome such a move. Small investors will be given more protection, and then building management will be made more transparent. You need 20% of the owners to pass the resolutions on the major maintenance projects. And owners, some of the owners need to attend in person. There's a particular threshold. In this way, owners will be encouraged to take part in the discussion of the resolutions concerning the maintenance works. In this way, we can avoid unnecessary disputes and the resolution will not become controversial. But then some owners have said that if you raise the threshold of owners who need to attend in person, it may result in a lack of quorum. Well, among the recommended changes, the administration would like to further clarify the instrument of proxies. The government is going to amend the guidelines. It is a move in the right direction. But then owners and also the owners' corporations are aware of the manipulation of the outcome of resolution discussion by gathering a large number of proxies. This is a gray area, and so ulterior motives can win. I think it's good to amend the BMO. What is important is to make sure that there will be better safeguards to prevent somebody holding a large number of proxies so as to influence the outcome of the discussion. We know that BM is a very controversial area. Currently, we haven't got a single department dedicated to the job. The DAB would like to see the establishment of a council on building maintenance, and we should invite different stakeholders like the professionals, the URA, ICAC, and other departments to take part so that they can give advice to small owners and owners' corporations so as to drive out bid rigging. In particular, the council can check the validity of the quotes in the tender result, and in this way, owners will be given some help in relation to the smart tender initiative. I think it is a good idea. However, when we go to the district, it is said that the smart tender scheme is a good thing. So I hope that this can be extended, and I hope that owners can find some assistance on the platform. We hope that the tendering exercise will be open and fair. What is regrettable is that the government saying that $300 million will be set aside to promote the smart tender scheme. It is late, but it is better than never. I hope that in this way, more owners will be encouraged to take part in the scheme and benefit from the scheme. Our assessment is that under the new scheme, about 3,000 owners, corporations, or other residents' organizations will benefit, amounting to 4,800 blocks. Recently, I've dealt with the maintenance dispute at On Key Court in Outer Kok. Owners were angry and they protested. I think the government should help. Currently, we have got staff from the Home Affairs Department at the front line, extending help to the owners. I think the government should enforce the work, and I think there should be a dedicated team of officers. And at the level of law enforcement, I think the government must make sure that the law enforcement agents have sufficient resources to carry out investigation so as to drive out the anti-competition acts, and we should enhance the penalty so as to have sufficient deterrent effect. Public education is important. Publicity will mean that owners will be put on the alert and owners will understand how to defend their interests. I hope that today's debate will let the government understand that we cannot afford to drag our feet on resolving such problems. We need to expedite so that we can tackle the problem of bid rigging. I so submit. Thank you. Chen Heng. Thank you, Mr. President. Once again, we are here to talk about ways to tackle bid rigging. In the area of building management and maintenance, small owners are not on a par with those who are knowledgeable, say, for example, the consultants and the contractors. In fact, the small landowners just cannot challenge them. And we have seen the infiltration of triad societies into the market. If you just count on the owners to organize themselves, I don't think they can really fight and win the battle. Sometimes when a cartel is aware that maintenance works are upcoming, they will even buy a few flats in the housing development so as to manipulate the result. This is because it is a very lucrative market. An assessment has told us that after bid rigging, they can fetch a much higher price, say, for example, even $200 million out of a single development. Some professionals and some authorized persons are also colluding with others so as to provide a one-stop service. They can open numerous companies. If they're exposed, then they just disband the company. I have already told the CE designate, Mrs. Carrie Lam, and I've presented evidence to her. I can prove that there was this consultant bidding for a tender. It was found out, and then it changed its business name, and it went back to that housing development, and they were able to get the bid. So it has become something very serious. If the consultant would like to be awarded the contract, of course, it has to go there to carry out extensive work. it may try to divide the owners, or they will try to get the support of certain owners. So they try to do some groundwork in the first place, and this is done at the expense of the small property owners. Some owners will try to protect themselves. They turn to the ICAC, the police, the district officers for help. Unfortunately, the departments are not acting in a coordinated fashion. The district office will send somebody to attend the OC's meeting, but they will always say that, well, we're not in a position to give legal advice. We're just attending. So what's the use of their attendance? For the ICAC, they will always say that there isn't evidence. If we have got evidence, then arrest could have been made. Of course, we count on the ICAC to gather evidence for us. And then for the rental safe, under the police, again, the police will say that they're too busy to help. Owners have nobody to turn to for help. And therefore, we have got some district people organizing themselves into an alliance to fight the battle. But all they can do is to remind the owners to be more alert. But for us to be engaged in anti-bid rigging activities, we may have some negative outcome. Sometimes people may gain political capital out of it. Sometimes owners will start to suspect each other because they cannot tell who is trying to have collusion for the sake of bid rigging. Therefore, there is no longer harmony among the neighbors in the housing development. They start to suspect each other. Your neighbor may disagree with you, and then you will no longer be greeting each other on your way out. But owners do not want to see this happening to their own development. What can we do? I think the government must abandon the previous approach, just relying on one or two initiatives. The smart tender scheme can help, but I don't think that should be the only way to take on the cartels. I think we need much more. I hope the government will no longer turn a blind eye to it. Must we always get a consultant in the first place? Other than the consultants, can we not get somebody else to help the owners as well? Mr. Wilson Orr suggested that we should set up an independent council, a committee, or a department so as to coordinate building maintenance. Departments should be represented, and the URA should also get somebody who's dedicated to the cause so that there will be coordinated work so that we can coordinate building maintenance. In this way, we can tackle bid rigging. The government has set aside $300 million. We don't want the money going down the drain because the money could have been spent on a very worthy cause. Now we are concentrating the money on one single project, that is building maintenance. We hope that we are not sort of encouraging more bid rigging. I hope the government will act and take on the bid riggers and help the owners, save the owners. Now, more and more works are underway, and then the costs and the prices are fluctuating greatly. So please help us set up a dedicated council or committee so as to help the owners. I have a lot of expectation of the new term of the government. I expect an announcement upon the beginning of the term.
Mr. Chan Kim-po. Thank you, Mr. President. I need to declare that I am the chairman of the Owners Corporation of a large housing estate in Hong Kong, and the building maintenance is the major pain in the neck for Hong Kong people, and Hong Kong people lead a very busy life, and even after work, if they need to struggle over these problems, it's really a pain for them. I know many owners who face the huge sums of building maintenance works, and the problem is getting more and more serious because we're talking about the bid rigging of projects costing dozens of millions of dollars, thereby attracting the unscrupulous to commit crime. And the unscrupulous can easily reap a profit. I have been engaging in the work of the OC for many years. I have the first-hand experience of the loopholes in our system. For example, in the formation of OCs, the appointment of proxy, the proxy instrument, and passage of resolution at OC general meetings. Because of these loopholes, the undesirable elements can continue with the unscrupulous practice. I'm not going to repeat them because over the years we have been having similar motion debates in this council, including bid rigging, which is the topic today, and members have come up with different suggestions. All in all, legislative amendment is necessary to plug the loopholes, and I've already reflected my experience in detail to the government, and in the consultation exercise recently launched on the BMO, the government has also taken on board some of my views. There are a number of proposals. For example, the quorum of meeting in determining the large-scale maintenance projects has been raised to 10%, and the owners should attend in person when resolutions on large-scale maintenance projects are passed. And also, in the past, proxy instruments were accepted, and now owners may indicate their voting instructions in the proxy instruments, and the proxy should only should not act as more than 5% of the owners. But I understand that at the same time, the government will also continue to use the code of practice and draw best practices. And I do have strong reservations because the COPs are not binding, and the COPs are actually futile in deterring the syndicates. Such a relaxed approach has caused owners to decide whether to form an OC or not. As a result, many buildings have set up OCs, but then after some time, many loopholes begin to appear. The government believes that if we make it mandatory, it will discourage owners from participating in the affairs of OCs. But we should understand that it's not about criminal liability, but we must stop those with intention not to become OC members, and at least there should be some criminal liability. And we also need the law enforcement agency and the departments to monitor the situation, and at present it's the duty of the district office and the Home Affairs Department, but they already have a workload. I therefore support the idea of a dedicated department that, for example, for the URA introducing the smart tender scheme, if it is tasked to supervise building maintenance and building management, it will be more effective in deterring the syndicates and promoting building management. And Mr. Paul Chan, Financial Secretary, in this year's budget proposes that the $300 million will be reserved for the smart tender scheme, and it is expected that the 4,500 buildings would benefit from the scheme in the coming 5 years. I welcome this initiative, and also the application criteria will be relaxed. I hope that the government can step up publicity in this regard and even take the initiative to invite the needy buildings to take part in it. I believe that with the help of the smart tender scheme, a lot of buildings will be able to undergo building maintenance works. By then, we can set up a database. Mr. Ray Chan. Mr. President, well, Hong Kong is experiencing the peak in carrying out building maintenance works, and therefore bid rigging has become more and more serious. The Fact Wire earlier analyzed some 200 projects with Professor Leung Tin-Wai and discovered an extensive spreading of bid rigging. For example, the excessively low consultancy fee and anti-competitive conduct, and at least 75 housing estates received subsidy from the government, accounting for 1/3. 67 buildings came from the Operation Building Bright, and also 9 from the Integrated Building Maintenance Service Assistance Scheme. And it is found that even bid rigging in subsidized housing is more or less the same as what's happening in the private market. So let's imagine how rampant the problem is. As Mr. Dale Wong said, you cannot be too outrageous in engaging in bid rigging, and you cannot prevent competition, and that is why they would create this situation where it seems that there is competition. And even if we know we're certain about a certain bidder, there are still other contractors submitting bidders so as to create a fake competition. In some cases, disputes may involve exorbitant sums of building works, substandard consultancy service, as the majority of housing estates are provided with a progress report during building maintenance works are in progress. The maintenance work, it will be too late for owners to discover what is wrong. According to the BMO, there is a statutory power for owners to form OC, but then because of lack of resources, very easily the unscrupulous would make use of OCs as the shield, and the majority of owners are not familiar with the construction industry, and many of them rely on the advice of the consultant. If unfortunately the owners have engaged an unscrupulous consultant, then the housing estate would become the ill-gotten gain of these unscrupulous contractors. And I also received a complaint from Garden Vista in relation to bid rigging and exorbitant building maintenance sums. There was a collusion involving a bribe of $2.6 million and $1.5 million, which accounted for 6.7% of the total sum as the reward for awarding the contract. And also 60% of housing estates are managed by property management companies, but their quality varies. So it's like choosing a boyfriend or a girlfriend. If you find a good PMC, then you're lucky. Otherwise, your building may be facing a lot of troubles. For example, the PMCs may be overcharging, posing a burden on owners, and even worse, the PMC may not be properly managing disputes, causing owners to have to take the matter to court. This year, the administration has come up with the proposal to review the BMO, including the 3-tier system for large-scale maintenance projects, and also the quorum will be increased from 10 to 20%, and at least 10% of voters must attend the meeting in person, and each proxy must not represent more than 5% of owners. But in reality, when it comes to discussing construction projects, there may be disputes and between the owners and the OC, and the OC would resort to different ways to delay the calling for a general meeting. And some OC members may resign as an excuse to delay the general meeting. Well, if such delaying tactics are deployed, So then by the time the building maintenance works begin, owners will be helpless. Now, this legislative amendment does not contain anything to tackle this problem. For housing estates, they have number of units ranging from several hundred to several thousand, and the sums may range from millions to tens of millions of dollars. I think that the OC members should carry some liability if they continue to disregard the government, using the excuse that they work on a voluntary basis and they should not be burdened by criminal liability. We should consider their duties because they monitor the budget of the housing estate and they may collude with the syndicates. The government, therefore, should set up a building maintenance works authority as soon as possible with powers to oversee building maintenance works and also be able to revise the code of practices and guidelines with binding effect, and also impose punishment on non-compliant contractors, such as revocation of their license, and so as to ensure quality of the industry and to prevent a handful from damaging the reputation of the industry, and also to help owners in choosing the right contractors or management companies so that owners in Hong Kong, building owners in Hong Kong can enjoy better service in building management and maintenance.
Dr. Edward Yiu. Thank you, President. Well, I've got 3 hats, and I speak on the under them one in them one by one. First of all, I am a surveyor. I have experience in building repair, and I have studied over a number of years on building management and also tender exercises in buildings, in building projects. And recently, I am a victim in a bid rigging case, so I have first-hand information. So, with my 3 hats, I can see that the core problem lies with this. On one hand, the government required buildings to go through repair projects without giving any assistance. On the other hand, when it comes to illegitimate bid rigging activities, they condone such activities. So on one hand, they mandate repair works to be done. On the other hand, they give a free rein to malefactors engaging in bid rigging and illegal activities. Some members have already pointed this out. The biggest loophole is the proxy and proxies being falsified in the residents' general meetings. In a recent panel meeting, victims of these cases have pointed out that the current proxy system is fraught with flaws. On one hand, the law allows proxy, but at the same time, the government doesn't provide any help. They have not assisted in verifying the proxy instruments, and they would not answer questions related to proxy instruments from owners. Even there is evidence showing that some people use false proxy votes. The government will not get involved. Even when a report is made with the police, you will never hear about it again. So when it comes to false proxy instruments, make malefactors become well aware of this loophole. They know that they can use false proxies to get money from building management, maintenance, and repair contracts. However, small owners can't do anything. They can't even report and get a result. The government said that it is a dispute between you yourself and the owners' corporations. Just resolve it yourself. The owners only have a very humble request. They just want to check the authenticity of these proxies. Well, if they are not allowed to check it, can we engage an independent professional to check the authenticity? The answer is still no. The government do not provide any assistance, so it's a giant loophole. In annual general meetings, some people will use false proxies to do whatever they want. For outspoken owners, they cast out on the result of the vote. These outspoken owners are forced to climb up because they are subject to threats, because very often these activities involve triad members. So the outspoken members would not be able to get to the bottom of it. And these often involved property management companies, consultants, and contractors. As a result, owners have lost confidence. Even owners among themselves have lost trust. But the government requires them to have their buildings repaired. So the system has completely collapsed. The only way out is to have someone who has got credibility to restore confidence. So the government should get involved on its own initiative to become the impartial party. They should be involved in checking proxy instruments to chair tender exercises and to chair AGMs. We need someone who is impartial and independent so that small owners will have faith that someone independent is actually chairing the process. And I've said in the past that if there are professional teams set up under district councils to assist in building repair, they are public officials and they have expertise to monitor tender exercise and to be able to analyze project price so that malefactors cannot get involved. They will be able to assist in the whole repair process, and they will also help to deal with unlawful building structures. You use teams of professionals in the district to help owners to restore confidence, and they will also act as gatekeepers. Ms. Dari Lee. Mr. President, starting from year 2000 to now, it's been close to 17 years when I've been a district councillor. I am a district councillor from Kowloon City. It's one of the districts with the most number of old buildings. So in the past decade, I spent most of my time to assist in very old buildings to deal with relevant issues. Say, for example, various repair orders from the government and also building management. I have first-hand experience and information in this regard. In the past decade, I see that the problem gets more and more complicated. Of course, one of the reasons is that these buildings get older. I've been a district councillor for over a decade. Well, looking at the redevelopment rate of URA and also in the private sector, I see that the aging of buildings will continue. Well, there will be leakage. There are problems with unlawful building structure, building works. There is a bigger incentive to have subdivided flats because all buildings usually are larger, so they can be partitioned into subdivided flats for more profit. So we have buildings that is 40, 50 years old, suffering from problems of leakage and possibly subdivided flats. On top of that, well, there are more and more orders issued by the government. At the beginning of my career as a district councillor, most of the time I helped in dealing with repairs, and then there was the mandatory building inspection scheme and also the mandatory windows inspection scheme. So very often in one single building over different times they receive various repair orders, excluding orders coming from the EMSD in relation to WR2. So owners are off their feet the whole time trying to meet the requirements of various orders dealing with proper building management and repair. Most of the time, the owners are already old. The owners themselves are old. So given that, we see more and more serious problems of bid rigging cases. And indeed, they are more organized than before, and sometimes they even provide a one-stop service. Sometimes they identified older buildings or residential developments that are larger. They will first get proxies to enter OCs to be a member, and then they would advocate or promote repair. And in AGMs, they will make use of proxies to participate. Well, if you are a district councillor and if you attend various AGMs, you will see the same faces. And every time when it comes to repair projects, there will be an uproar. Well, I do see these bid rigging syndicates infiltrating into various buildings. And on top of that, project cost increases because of bid rigging, because of shortage of manpower, increase in wages, material, and more numbers of repair projects. Nowadays, it seems common to have projects that stands at about $100,000 and $200,000, much more than before. Old owners, humble owners, will not be able to afford that. So I do hope that the new government will accord priority on dealing with building issues and also bid rigging issues. Otherwise, I would think that the time bomb will get more and more destructive. And this is also one of the reasons why people are unhappy. The DAB moves some amendments, and I would just like to go through the suggestions. First, to plug loopholes of BMO. And indeed, the government has faced the problem, and I'm a member of the review committee of. I am the review committee of the BMO. Of course, well, there are still some outstanding controversies. But what the government will not face is that there is no enforcement of this ordinance, the building management ordinance, because it requires that you give a notice of 7 days. But if some OCs fail to do that, you will have to write a complaint to the HAD. And then if you want enforcement, you will have to take out a lawsuit in the Lands Tribunal. From my experience, no one will spend money to take the case to the Lands Tribunal just to enforce that. So for those who are obedient, they will do it anyway, but those who are not, they will continue to ignore you. So the new government should face the problem of no enforcement in relation to the BMO. There is another issue. Well, the setting up of a Building Affairs Tribunal. This will be a court to deal with the issue. Lastly, when it comes to subsidy, the government maybe can be more generous. Well, if you give so much for repair in public housing, then why don't you give subsidies to old owners? On top of that, you can give technical support. Well, currently, Smart Tender Scheme will only help with tender exercise, but not on technical matters. I hope the Secretary will think out of the box, otherwise dissatisfaction will build up.
Dr. KK Kwok. Thank you, Mr. President. I won't repeat points already mentioned by other members. Hong Kong is a place where we would like to have a clean government, a clean society, and we emphasize integrity. However, when it comes to building maintenance, the government has given us the impression that the government just couldn't care less, and the government seems to be incompetent in tackling the problems. Bid rigging isn't something new. It is only when there was this outrageous case in Garden Vista in Sha Tin, then we became more aware of the problem because someone was sent to jail for that matter. But then this is but the tip of the iceberg. Sometimes we seem to get used to the bid rigging. Just now, members talked about older buildings. A few years back, my friend was residing in a luxury flat in Ho Man Tin. Somebody spotted the chance. He bought a unit in the development, and then he became a member of the owners' corporation. He spent a lot of time to build up a network, and he collected a number of proxies. At the end of the day, he was able to introduce maintenance works of a value of $100 million. The owners were divided into two camps, and the case went to the court. I just want to say that the government has tolerated the situation, and then the criminals were able to make huge profits out of this sector. We need to change the law. The BMO, the Buildings Maintenance Ordinance, should be amended to plug the loopholes. Say, for example, we want to have at least 20% of the owners attending a general meeting. There should be stricter requirements concerning the use of proxies. But then the owners may not be able to benefit from the amendments to the BMO. For small owners who need to go to work, they would just be too busy to attend a general meeting that takes place in the evening, even though he knows full well that there's a resolution going to be passed measuring tens of millions of dollars for building maintenance. Yes, there is this smart tender scheme, but then there are many buildings that are eligible for this scheme. We have got different kinds of orders and requirements, like replacing your windows, tackling water seepage, etc. Not to mention fire services orders. So many owners have headaches about different sorts of building problems. In 8 or 10 years down the road, a building would be subject to mandatory window inspection, etc. In 2014, the Hong Kong Surveyors Institute said that the government should consider setting up a building maintenance works authority. It is said that if we have such a public body, then there is a way to make sure that we can restore public confidence in building maintenance works. This is a good idea. This is the proper way forward, but the government is dragging the feet, and I cannot understand. The government is willing to spend billions or tens of billions of dollars on white elephant projects, or the government will just spend hundreds of millions of dollars on celebrating the 20th anniversary. Now, owners are not asking for subsidies. They just want an authority to be set up so that we have dedicated professionals as well as law enforcement agents like the ICAC, etc., will be sitting on the board, and then they can give help to the owners. Currently, the district office staff members are only attending owners' meetings and do nothing. They are just in attendance because whenever there is a question about CAP 344, they will say that it is not their business. What it means that this will only encourage more opportunists who would like to exploit the loopholes. They know that despite the presence of district office staff members, they can find a way to have bid rigging, and they can try to win the consultant's contract by putting in a low bid, and gradually they will make more profits by having their own contractors. I'm not sure whether the government is blind or deaf. Maybe the government isn't aware of all the problems. Now, across the political spectrum, we all agree that something should be done. Seldom have we asked for government intervention. Now, usually in our society, we would rather have the government staying away. But then for building management and building maintenance disputes, we have professionals monitoring of works and tendering, etc. So I think if we have the authority, it means that we can maintain a register. And many professional bodies are willing to provide voluntary service, but then it is impossible for them to enter the premises because they are afraid that they haven't got the mandate. They may be challenged, and a report or a complaint will be lodged with the ICAC. So you need to give them a legitimate course so that owners will become confident in the whole matter. Now, despite this debate and despite the passing of the motion and the amendments, if the government does nothing, we can still not make any improvements. Mr. LAM Kwok-fan, a house is not a home. But of course in Hong Kong, many people live in flats, not a house. Perhaps I should change it to read, a flat is not a home. Now, you may save a lot of money so as to buy a property, but then that's not the end of your nightmare. This is because the way we sell our flats is very funny. Now, we have got the divided and undivided shares, and then it is very different from the case overseas. In overseas countries, everything is clear. You own your own lot, and then the street or the road outside your house is to be managed together. Now we have this motion debate. This is about combating bid rigging to defend the rights and interests of property owners. I think we have to insert the word small property owners. For the developer, I think the developer will have its way because they have the biased deed of mutual covenant, which works to the benefit of the developer. It is difficult for the property owners to veto the terms in the DMC, and this is going to create problems. Under the BMO, usually the owner of the shopping mall have more shares than the small property owners who live upstairs. Usually the developer will lease the shopping mall to the shopkeepers. So what happens is that usually the businessmen will own more shares than the residential flat owners because we don't count the number of households, rather we count the shares. So you work for the benefit of the owners of the downstairs shopping mall. But then the residential owners are really frustrated. The renovation and maintenance works would be biased towards the shopping mall owners. I think, after all, it is a matter of the market. When we regard our residential units as an item of investment, when the property right is divided into so many shares, then it is difficult to keep it under control. And I think it is time for the government to intervene. Now, many small owners have been suffering. Is the government willing to come up with a one-off solution and come up with service not available from the private market? Just now, many members have said that district office staff members, though attending a general meeting of the owners, cannot extend any help. There was this occasion that a lady was slapped on the face, and nothing could be done. And then I had to call the police, and the district office staff member could not and would not do anything. They can't attend to such matters because they won't sort of stick their head or stick their neck out, and they won't take the risk. Well, you need to be at the front line. You need to get involved. Now, I have got 5 court cases underway, and I think the government just has more than enough lawyers to help the owners. Can the government always blame it on having to be neutral? And then for the public rental flats under the tenant purchase scheme, the government has come up with hundreds of millions of dollars to help with the renovation and repair. But then it is a lucrative sector. Many people understand that there's just a lot of money available. So criminals may even want to buy a flat so as to become an owner. So you can then move on to become the chairman of an owner's corporation. This is the case of Minghua Estate. Not all the public rental flats have been sold. So the government would always say that the government remains neutral. There won't be any intervention. Now, if the market forces are facilitating, then of course we don't need the government to intervene. If not, then the government must do something about it. Just like owning a dog. If the dog is good, then you get along with it very well. But then if the dog suffers from a disease, then you have to take care of it. Otherwise, it will go mad and it will bite you. Now, the government is saying that for the properties of the property owners, that's their business, and the government's not going to do anything about it. We need to revise the law. For public rental flats, the problem is still serious, not to mention the private flats. Now the government is coming up with $300 million. Of course, it is a profitable business. Now the housing society is stepping beyond its reach. Now what about the URA? The URA is there to resume old buildings so as to redevelop the site. The management team enjoys a high salary. They won't care about such maintenance work. So if you're serious about it, you need $1.3 billion, not $300 million. You need an authority, just like in the case of the ICC, so that you get all those who are experts, and then you consult the views and then amend the law. So you need to spend $3 billion, not $300 million.
But
Mr. Ho Kwok-fan, thank you, Mr. President. I speak in support of Mr. Kwok Wai-keung's amendment. I am the district councillor of the constituency with HOS flats, and bid rigging is an issue close to the heart of my constituents, especially one of my the housing estates in my constituency also was involved in a bid rigging incident. Earlier, a media organization collected data and found that 1/3 of the 200 companies in the construction industry were involved in the bid rigging incidents, and half of the contractors, 10 contractors took up 80% of all the maintenance projects. What about other engineering companies? We have the suspicion that they only take part in, they are shell companies taking part in bid rigging. Otherwise, they will, since they do not get any business, it is impossible for them to survive. Bid rigging has been a long-standing problem in Hong Kong, but we haven't seen any improvement. In 2016, according to the Competition Commission, they received 300 cases of bid rigging. The picture is undesirable. It seems that the government is helpless in tackling the problem. Bid rigging is a norm in the market, then the government should be responsible, because in the past, as I understand, the government would like to adopt this approach, just like shares in a company, so that owners can act as shareholders in managing their housing estate or building. But there are some differences causing the failure of owners' cooperation. First of all, when I buy shares, I take the initiative to buy shares, but when I live in a flat, building maintenance may not be something that I'll take my own initiative. And also for OC's general meeting, the approach is much more relaxed than an AGM of a company. The Home Affairs Department may be overseeing the formulation of OCs under Cap 344, but we do not have an authority like SFC overseeing the operation of companies. Another point, there aren't many choices for owners. For example, for the MTRCL, shareholders may be asked whether they want to have a dividend or not. But for small owners, down to every detail. For example, whether we should use tiles or marble for marbled tiles for the lobby. These are things that owners have to think about. But many residents may not have the energy or time to deal with these issues after work. Point number 4. For shareholders' meetings, the proxy instruments are much more stringent, just like the proposal in the administration's proposal. The requirement will be tightened, but at the moment, the proxies are still allowed to vote however they want. So I can only say that this is a substandard version of or substandard version modeling on the AGM of a company or a shareholding system of a company. That's why we are unable to tackle the problem of bid rigging. Another point is that we have we lack transparency in the flow of information in the market, such that owners cannot make an informed choice. So if we do not have information for owners, how can we prevent bid rigging? For example, the other housing estate nearby may opt for more extravagant maintenance scheme, whereas our housing estate may not may wish to take a more frugal approach. So we cannot make comparison with other housing estates, and therefore we become the target of syndicates. And in 2012, the government introduced a mandatory window and building inspection scheme, which is good news to owners, especially for aged buildings and housing estates. A mandatory inspection scheme is necessary. However, because of the bad practices in the industry, bid rigging has become norm. Because of this good soil provided by the BWIS and MBIS, I think the government should take up more responsibility. I don't think the government doesn't understand the problem. For example, for CAP 344, the BMO, it involves building maintenance work, such as the definition of large-scale maintenance works, etc. But to effectively combat bid rigging, I think there is still a long way to go. I hope that the Development Bureau and the Home Affairs Bureau can complete the review of the existing legislation and increase more manpower resources to the the district office to cope with the ever more increasing workload. Because I have this first-hand experience, the frontline liaison officers of the district office really have a very heavy burden. They may need to oversee 4 or 5 housing estates at a time. I hope that more resources can be provided to improve the whole system and safeguard the rights of small owners. I also agree with Mr. Kwok Wai-keung's amendment, which says that the government should develop a comprehensive maintenance information platform and database to provide property owners with professional or information to make informed choices and make assessment, because at the moment we are comparing apple with watermelon or durians, and this is not reasonable. All in all, on the point of combating bid rigging, the government must show determination and to take control of the matter and take a two-pronged approach. Mr. Frankie Yik. Mr. President, bid rigging has caused a lot of mental pressure and financial pressure on OCs and small owners. Many owners have to put up with the substandard quality of works and also exorbitant maintenance fees. Garden Vista is a good example, and at the same time, owners are responsible for keeping their buildings in shape to prevent a repeat of the collapse incident in Matawai Road. Owners, at the same time, in order to fulfill their responsibilities, are required to engage their own contractor, and many owners are not familiar with this area of work. They only entrust the owners' corporation to do so, causing syndicates to have opportunities to make a gain by way of bid rigging. These syndicates may be formed by different contractors. They may look unrelated, and they may take part in a tendering process, and they may consist of both consultants and also contractors. The Liberal Party believes that the loopholes of the legislation should be plugged. Although the administration has put forward some legislative amendment proposals earlier, we question the effectiveness of these amendments in plugging loopholes. In passing resolutions in relation to large-scale maintenance projects, it is said that the quorum should be raised from 10% to 20%, and the percentage of passage of resolutions have been raised from 50% for the purpose of encouraging owners' participation and preventing any abuse of the system. However, in practice, very often the meeting will be aborted for lack of quorum, also causing the OC's work to be ever more difficult. And in terms of monitoring the situation, in 2012 to 2015, in relation to there were 3,800 cases of suspected corruption in building maintenance work matters, but only 121 persons were involved, with only 106 convicted. The conviction rate is so low that bid rigging continues to be prevalent even until today. The Liberal Party believes that more should be provided to protect small owners. We believe that criminal sanctions should be imposed to serve as deterrents to curb the spreading of syndicates for large-scale maintenance projects. They entail exorbitant sums, and there should be a cooling-off period for owners to examine the terms of agreement of the maintenance contract, and they should be allowed to rescind the contract free of any condition to protect the interests of small owners. We have liaison groups set up in different districts to help small owners, but they have a heavy workload. They need to hold relevant training courses for PMCs and OCs, and also give advice to OCs, as well as arranging for professional mediation services. In the beginning of 2015, the government introduced the free mediation, the building maintenance free mediation service, which is a 2-year pilot scheme. The pilot scheme ended in February this year. The result is disappointing because the scheme has not helped resolve disputes at all. Apart from increasing manpower, the government should also enhance the training on disputes resolution for liaison officers. And also in May 2016, the URA launched the Smart Tender Scheme to provide support for owners and OCs intending to go through building maintenance works. In order to further promote the Smart Tender Scheme, in this year's budget, $300 million has been reserved so that owners of private buildings can take part in Smart Tender Scheme at a concessionary rate. We support that. Well, although the Liberal Party believes that the setting of a building maintenance works authority is a duplication of resources, because of the prevailing problem, a unified authority can coordinate things and also implement the licensing system. The Liberal Party, therefore, does not object to this suggestion. We hope that by doing so, we can tackle the problem of bid rigging.
Mr. Lam Cheuk-ting, you may now speak on the amendments. You have 5 minutes. First of all, I thank Mr. Edward Lau, Mr. Alvin YEUNG, Mr. Fernando CHEUNG, and Mr. KWOK Wai-keung for their amendments, and I also thank members for speaking. First of all, I'd like to speak on Mr. Edward Lau's amendment. I noticed that Mr. Lau asked to set up a data bank of maintenance, of building maintenance. There are some similar proposals coming from other members. I am a member of the Anti-Bid Rigging Alliance, and I'm aware of that. The setting up of a data bank will provide information for small owners' reference, because in the face of bid rigging syndicates with participation of professionals, they do need a lot of information. So this building maintenance data bank is very important to small owners.
Dr. Fernando CHEUNG and also Mr. Edward Lau have said that the Smart Tender Scheme should be enhanced. I think this is the right direction. Now, the Smart Tender Scheme has been launched as a pilot scheme for a short period of time. It did help, but I don't think we can only we should rely on that alone. But at least there would be professionals giving independent advice to the owners for their reference. Therefore, we also support the relevant amendments. And then Mr. Alvin YEUNG referred to the instruments appointing proxies. Many members also refer to this very serious problem. Now, we need to regulate their proxies, but then currently this is not adequate. I've already said that I can certainly succeed if I choose to engage in bid rigging, because the government just doesn't care about the loopholes concerning the proxies, and the loopholes are being exploited to manipulate the owners' meetings. Mr. Yeung also advocated a cooling-off period, an idea also shared by Fernando CHEUNG, so that there would be a cooling-off period in the decision-making process. We also agree with the idea, but then we have to avoid causing confusion in the decision-making process. The government should consider that. And then Mr. KWOK Wai-keung said that the police force, the ICC, and the Competition Commission should receive a boost in terms of the manpower, in particular the Competition Commission. I had talked to the Competition Commission. I've been told that for the litigation fund, the sum of money is limited. For the Commission to take anybody to court, probably they are facing cartels or engage in bid rigging, and then the amount of money involved will be huge. So we hope that the administration will take on board our view, that is, we should enhance the manpower resources of the Competition Commission so as to tackle bid rigging. Mr. President, members have also suggested that we should set up a building affairs tribunal. Mr. KWOK Wai-keung is one of the members making such a suggestion, and I believe that this is a good idea. Perhaps the government should try to see if we can have a tribunal so as to help owners resolve building management and building maintenance disputes. It will be a cheaper approach, and then we don't have to go to the land tribunal, which will be very costly. Lastly, Mr. President, some members would like to take away the reference to trial infiltration in my motion. They also wondered whether trial involvement is serious. I just want to tell you that in the past, it would be very difficult if you did not have the help of tribe members, not to mention bid rigging. And then in the past, when owners try to air a legitimate challenge, then you will then see triad-looking people lingering around in the housing development, and then the outspoken owners will be forced to become silent.
Secretary for Development. Mr. President, I thank Mr. LAM Cheuk-ting for moving today's motion and the amendments from 4 other members. I also thank members for speaking on this motion, setting out the difficulties encountered. They have also given valuable suggestions on combating and preventing bid rigging. I will first answer in relation to enforcement and technical support. Shortly afterwards, the Secretary for Home Affairs will reply on other areas. Well, there is a suggestion to have the Buildings Maintenance Work Authority to standardize the code of ethics and also quality of maintenance, and on top of that, to set up a statutory organization to set down practice standards and guidelines. As I said at the beginning, currently there are a number of organizations enforcing the law in relation to bid rigging. The Building Authority and relevant professional bodies have also set down the requirements of professionals and also contractors. Apart from enforcement and regulation, well, a lot of assistance in relation to technical support is given by these organizations, including code of practice and consultation. So technical support is available for them. The HAD also launched extensive public education to encourage owners to participate in OC meetings to further protect their interests. The suggestions made by members will be seriously considered. And I thank members for asking whether there is sufficient resources to these law enforcement agencies. They will oversee their resources and make arrangements accordingly. If we are to set up another authority or a statutory organization, there will be a lot of preparation, and if it involves a legislative amendment, it will take even longer. So it will not be able to tackle imminent problems. On top of that, there will be additional resources required. Some of it may be shifted on to small owners, and we have to be very careful with that. When it comes to maintenance, building maintenance, it may involve building management. Separately setting up organizations will not make it easier to get involved with these issues. On top of that, currently there are some dedicated organizations that are given statutory power to oversee maintenance projects. We don't think that adding any more to that will help in any way. I myself and colleagues of the Development Bureau and the URA in March attended a panel meeting to consult members on the smart tender scheme. I'm glad to hear that members in general support this scheme. On that day and today, I've had a lot of suggestions. As I said at the outset, that we're working with the URA on the launching details of the concessionary fees in the next quarter. Some members ask for the scope of a smart tender scheme to cover monitoring progress and to check delivery, to check the result. I believe that you all will agree that it's the responsibility of owners to take on building maintenance. Well, even if owners use the scheme, they still have to engage their own consultants to monitor progress and quality. And if there are doubts, owners may separately engage another supervisor to assist. Well, the scheme mainly provides sufficient information for owners so that they can properly use the information and the tender exercise on the electronic platform, but it cannot replace the responsibility on ensuring quality. Well, there are also suggestions about setting a one-stop service for maintenance information. Currently, on the URA, there is the Building Rehab Info Net with information uploaded to assist owners in various subsidized schemes and technical assistance. On top of that, there is also information about flowchart, FAQs, and also real cases experience sharing. Also, on top of that, there is a cost reference of buildings in different areas covering different sizes. On top of that, there is also information about various departments and APs and also registered audit or personnel. In addition to that, the ICAC asked the Hong Kong University to make use of the expenditure information under the Operation Building Bright to make available such information for owners to use for reference. Well, on top of existing websites, the URA is now working on a building rehabilitation platform to further support owners. This will provide one-stop information on building maintenance and repair, so that when owners, organization, and also property owners are planning for building maintenance, they will be able to use the information on finding a consultant, contractors, etc. When it comes to project cost, well, it depends on the scale, the quality and materials used. So it is difficult to make a direct comparison. However, given that the URA is considering preparing a document setting out the cost of common repair items for reference. Starting from the end of the year before, the URA is talking to the trade on this rehabilitation platform to provide better assistance to owners. In order to effectively tackle bid rigging, we all have to work together. Owners will have to put in time and effort to be involved in the preparation and supervision of building maintenance. We'll continue to listen to views and suggestions, and if necessary, launch new measures and support. I so submit.
Secretary for Home Affairs. Mr. President, I once again thank members who have spoken and who have provided a lot of valuable and useful views on combating bid rigging to defend the rights and interests of property owners. Just now, the Secretary for Development already explained in detail matters relating to the government's enforcement, technical support, and building maintenance and bid rigging. I will respond to members' other comments, including the legislative proposal to amend the BMO, support for OCs and owners, and publicity in education. I must emphasize that the objective of the BMO is to provide a legal framework to assist owners to properly manage their buildings. The legislative amendment exercise seeks to enhance the transparency in the arrangement of building maintenance works by OCs and to enhance an owner's participation, which can minimize the chance of the works being manipulated by some owners with other intentions, and to minimize disputes arising from large-scale maintenance projects among owners, OCs, and PMCs. Since last year, we have put forward 20+ recommendations to amend the legislation, and this year in March, we put forward further legislative amendment proposals and administrative measures. We consulted the panel's views, and we also put forward 34 new legislative and administration measures in 9 aspects. On large-scale maintenance projects, apart from raising the quorum of the General Meeting for the passage of resolution, we further require that a certain number of owners be attending the meeting in person to enhance their participation. And on the definition of large-scale maintenance project, we have provided more details by setting the amount, and we've also been suggested using the average audited annual expenditure of the OC for the past 3 years as a basis to avoid artificial inflation of the annual budget and circumvent the definition of large-scale maintenance projects. Also, if the consultant's proposed amount complies with the procurement terms, and that is 20% of the annual budget, it must be passed at the resolution must be passed at the meeting of the OC. And if we require that the consultant be chosen at the general meeting of the OC on large-scale maintenance project, regardless of the sum, then it may lead to a number of OC's meetings being convened, and it may delay the resolution's passage. We must carefully consider this proposal. Some members suggest amending the provision relating to appointment of proxy to safeguard their rights. We totally agree that we should enhance the provision in this regard. Last year in May, we put forward a series of suggestions. For example, at least 24 hours before the holding of a meeting, the MC should, at a conspicuous place in the building, provide a list of proxy instruments until the 7 days after the meeting. And point number 5, each proxy must not hold more than 5% of the owners And point number 3, before calling for an OC meeting, the owners represented proxies and the third party being so appointed as proxies should be able to inspect the instrument of proxy which are declared to be void. And we have also issued administrative guidelines. We encourage the OCs to adopt the guidelines. To further plug the loophole on the abuse of proxy instruments, This year in March, we put forward further suggestions. For example, owners may indicate their voting instructions in the proxy documents, and the proxy instruments should be countersigned by the proxy, indicating, and a declaration should be made indicating that the proxies they hold are honestly procured and are true and accurate representation of the owner's voting instruction. Point number 3, the OC should keep the record of the proxies and the declaration above for at least 3 years. It should be, under the existing Section 36 of the BMO, a proxy holder who fabricate proxies or make false representation are criminally liable. After proposing some further legislative amendments since March, we have been closely liaising with different stakeholders and listening to their views. Our objective is to incorporate provisions that in the BMO in the second half of this year that are not in conflict with the code of the BMO into the code of practice or administrative guidelines. We encourage OCs to adopt them to address public's concerns as soon as possible. In March this year, we have proposed to expand the scope of power of the authority, and we've also proposed to introduce suitable criminal sanction under the BMO. In order to address members' concerns. To address the issue of non-performance of MCs and management vacuum, we propose to expand the scope of power of the authority such that under certain objective and stringent criteria, the authority is empowered to dissolve the non-compliant MC and to appoint a manager to re-elect the MC, and also to appoint a building management agent to deal with the management vacuum, and the remuneration and expenses of the relevant individuals would be treated as part of the management expenses. We also propose to include appropriate criminal sanction to ensure that the MC, PMC, and DMC managers would properly safekeep minutes and tender documents. And we also propose criminal liability for DMC manager and PMC which are unable to submit annual audited accounts as stipulated in the contract. In short, we take a three-pronged approach in amending the legislation. We'd like to encourage more owners to take part in the OC's affairs in person. We'd like to enhance the transparency of appointment of proxy and procurement, and we'd also like to mandate the safekeeping of records by OCs, DMCs, and PMCs for the sake of evidence submission in the future as necessary. I want to emphasize that although amending the BMO may not be tackling the root of the problem of bid rigging and the relevant criminal offences, by enhancing the degree of participation, transparency, and accountability, we can better safeguard the rights of owners and prevent the problem of bid rigging. On support for OCs and owners, as I mentioned in my opening remarks, that apart from the Building Management Dispute Resolution Service newly proposed and the existing support services provided by the Home Affairs Department, we will also roll out a new arrangement. The chairman of the MC and the PMC will need to sign on the checklist on a procedural propriety to confirm that the meeting has been convened according to procedure and the information of proxies have been disclosed according to the requirement. Any person failing to follow the requirement in the guidelines will need to explain to ensure transparency and accountability. On publicity and education, the Home Affairs Department and the district offices are actively working with other departments and organizations to enhance publicity and to assist owners in maintenance works. Over the past year, the Home Affairs Department altogether organized 124 workshops, seminars, and courses. The Home Affairs Department has also been working with tertiary institutions since 2011 in providing systematic training for OC members to enhance their capability in matters concerning building management and maintenance. In light of the new proposal we are conducting a series of public engagement activities to collect the views of owners, OCs, and other owners' organizations, PMCs, and stakeholders on the proposed legislative amendments. Today, many members have come up with new suggestions, and we find these suggestions valuable. We definitely will consider members' views, and before formally tabling the bill into the Council, we will definitely discuss member suggestions again. Mr. President, to effectively combat bid rigging, we must take a multi-pronged approach, and we relied on the joint effort of the community. We rely on owners' participation in effectively managing their buildings. I appeal to owners once again to fulfill their responsibility and to actively participate in building management work. As we said in the API, we should active participation in building management benefits all. The Home Affairs Department and district officers will continue to provide suitable support to assist owners in fulfilling their building management responsibilities.
I now call upon Honorable LAU Kwok-fan to move an amendment. President, I move that Honorable LAM Cheuk-ting's motion be amended. I propose the question to you that the amendment moved by Honorable LAU Kwok-fan to Honorable LAM Cheuk-ting's motion be passed. And I'll put a question to you as stated below. Those in favor, please raise their hands. Those against, please raise their hands. I think the question is agreed by majority respectively of each of the two groups of members, as those returned by FCs and those returned by GCs. Through direct elections for President, I declare the amendment passed. Honorable Alvin YEUNG, as Honorable LAU Kwok-fan's amendment has been passed, you may move your revised amendment. President, I move that Honorable LAM Cheuk-ting's motion, as amended by Honorable LAU Kwok-fan, be further amended by my revised amendment. I now propose the question to you that Honorable Alvin YEUNG's amendment to Honorable LAM Cheuk-ting's motion, as amended by Honorable LAU Kwok-fan, be passed. I now put a question to you as stated. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority, respectively, of each of the two groups of members, as those returned by FCs and those returned by GCs. Through direct elections for President, I declare the amendment passed. Dr. Honorable Fernando CHEUNG, as the amendments of Honorable LAU Kwok-fan and Honorable Alvin YEUNG have been passed, you may now move your revised amendment. President, I move that Honorable LAM Cheuk-ting's motion, as amended by Honorable LAU Kwok-fan and Honorable Alvin YEUNG, be further amended by my revised amendment. I now propose the question to you that Dr. Honorable Fernando CHEUNG's amendment to Honorable LAM Cheuk-ting's motion, as amended by Honorable LAU Kwok-fan and Honorable Alvin YEUNG, be passed. And I put a question to you as stated. Will those in favor please raise their hands? Those against, please raise their hands. I think the question is agreed by a majority, respectively, of each of the two groups of members, as those returned by FCs and those returned by GCs. Through direct elections for President, I declare the amendment passed. Honorable LAM Cheuk-ting, members have already been informed that as Dr. Honorable Fernando CHEUNG's amendment has been passed, Honorable KWOK Wai-keung has withdrawn his amendment. Honorable LAM Cheuk-ting, you still have 4 minutes to reply. Thereafter, the debate will come to a close. Honorable LAM Cheuk-ting, just now the Secretary for Development has said that he has grave reservations about the idea of setting up a building maintenance works authority, saying that law enforcement agencies have their functions and other professionals have also got a role to play. The authority, if it is to be set up, will incur an extra cost, and this will only add to the burden of the small property owners. The Secretary for Development has also said that it's better to come up with short-term solutions. It will take time to set up such an authority. I find it regrettable to hear this from Mr. Eric Ma. Now, in fact, the government has imposed a duty to maintain and repair the buildings on the smaller owners, and as a result, this has spread like fire, and many owners have suffered serious losses. Well, in fact, you should have nipped the problem in its bud. The problem has grown worse. We have come up with many recommendations, and yet you won't listen to us. The Hong Kong Surveyors Institute has come up with this recommendation. They have pointed out to me, saying that if we haven't got a statutory body which is dedicated to the task of building maintenance, and if you just count on the professional bodies which do not have a statutory mandate, it will be very difficult. The bid rigging cartels are very powerful and rich, and they're afraid that they may be taken to court by such bid rigging cartels for defamation. You may say that it will impose a heavy burden on the property owners, but they don't mind if they have to pay a levy of 1 to 2% to the government to set up the authority. But then we are talking about 100, 200, even $300 million being involved. Please don't say no to our idea. I want to take this opportunity to say that, in fact, the professional bodies must come back to the market of renovation and building maintenance. In the past, we used to have companies that were of good ethical standards, but then they couldn't withstand the intimidation of the triad elements, as well as those contractors and consultants who were engaged in bid rigging, so they have withdrawn. Now, many small owners have woken up to this problem. They know that they have to take an active role. They know that bid rigging carries a lot of risk. It is high time for the professional bodies, for the legitimate businesses to come back to the market. Only when there is genuine competition can we make sure that the prices come down to a reasonable level, and then we won't. It means that we won't allow the astronomical prices to become the market price. A few years ago, I started a campaign against bid rigging. I know that I have to go forward, and there's no way that I can turn back, and I have to push on until I win. There are the corrupt owners corporations and property management companies, as well as other corrupt elements. They form themselves into a huge cartel. We must win the battle. If not, then we are losing out, and we are talking about the millions of small property owners and their households. We have already covered a lot of ground, and we have come a long way. For us to continue with our fight and for us to succeed, we need the government's help. If the government hasn't got the will, if the government doesn't show that it's determined, if you do not enhance your efforts, then bid rigging would just revive, and you will become prevalent. Please take into account the interests of the small property owners, adopt our views, and set up a building maintenance works authority. Here, I would like to thank members who have moved amendments. I would like to thank members who spoke, members who supported the motion and the amendments. Thank you.
I now put the question to you, and that is that the motion moved by Mr. Lam Cheuk-ting as amended by Mr. LAU Kwok-fan, Mr. Alvin YEUNG, and Dr. Fernando CHEUNG be passed. Will those in favor please raise their hands? Those against please raise their hands. I think the question is agreed by a majority of each of the two groups of members present. I declare the motion passed. This council is now adjourned until the 14th of June 2017, Wednesday, 11 a.m.